Hello, my name is Josh Blackman, and I am the president of the Harlan Institute. I am joined by my good friend Julie Silverbrook in person for once to host the first round of the Harlan Institute-ConSource virtual Supreme Court competition. Julie, anything like that?
We're so pleased to have the students we have today from Lake Oswego High School to argue this round. And the finalists will go to the final round, which will be held in Philadelphia at the National Constitution Center on April 13th as part of their annual Freedom Day competition. So to our petitioners and respondents, good luck. We're about to get started.
Okay, so petitioners, can you please identify yourselves?
Hello, my name is Kelsey Talbot. And I'm Lauren Anderson.
Okay, very good. Respondents, can you please identify yourselves?
Hi, I'm McKenna Murray. My name's Sophie Kroon.
Okay, very good. All right, petitioner, whenever you're ready to proceed, you have 15 minutes.
May it please the court that I, Kelsey Talbot, and my partner, Lauren Anderson, represent the appellant, Ms. Abigail Fisher, in her case against the University of Texas at Austin. The question presented before the court today is if race-conscious affirmative action is consistent with the 14th Amendment to the United States Constitution. The facts of the case are as follows. Ms. Fisher was denied admission to the University of Texas at Austin in 2008 due to a racially discriminatory affirmative action policy set in place at the university in 2004. Affirmative action is a preferential treatment regarding admission to college for those of a minority race. Affirmative action must be evaluated under the strict scrutiny standard, and in order to pass this standard, a program must be narrowly tailored and have a compelling state interest. After reviewing the facts of the case, we conclude that the race-conscious affirmative action, such as that of the University of Texas at Austin, is not consistent with the 14th Amendment to the Constitution. In Hopwood v. Texas, the 5th District ruled that, quote, the University of Texas School of Law may not use race as a factor in deciding which applicants to admit in order to achieve a diverse student body, end quote. This led to the creation of the 10% rule, which would allow minority students of high academics to be admitted to any Texas university that is public automatically. But after the 10% rule, students must be evaluated under an admission system that determines acceptance on an unbalanced scale. In UT's proposal to consider race and ethnicity for admission, it defines classroom diversity as 2 African American students, 2 Hispanic students, and 2 Asian American students in each classroom. This policy amounts to a quota system in order to achieve diversity and takes applicants' race as a defining factor for admission. This quota, which has already been deemed unconstitutional in regions of California v. Bakke, invalidates UT's admission system and renders the admission system not narrowly tailored and does not pass the strict scrutiny standard. Furthermore, the University of Texas at Austin system of affirmative action violates the Equal Protection Clause of the 14th Amendment because it is not narrowly tailored. The system of affirmative action at UT is favored treatment, which is ruled impermissible in the case of Adirondack tenure. UT's unconstitutional use of a quota system blatantly favors those of a minority race, which guarantees that not all college applicants have equal protection under the law. Moreover, in the case of Bakke, Justice Powell states that ameliorating the effects of past discrimination would justify the remedial use of race, but the college could not inflict harm upon other groups in order to remedy past societal discrimination. By not being able to comply with the strict scrutiny standard, UT is not adhering to the current law. And because of this question regarding racial classification, not all persons are being equally protected under the law, thus violating the Equal Protection Clause.
All right, Counselor. If I may ask a question, thank you, Counselor. Can you discuss a little bit about the history of the 14th Amendment and how it should inform our discussion and interpretation of the case before us today?
Did you say inform? Sorry.
Yeah. How should the history of the 14th Amendment affect our discussion today?
I think something very important is that the 14th Amendment is a series of civil rights amendments that happened to free the slaves. It was the 13th Amendment that effectively freed the slaves from slavery. The 14th Amendment granted citizenship, and the 15th Amendment granted voting rights to Black men. And so in these 3 amendments, we see African Americans being brought up to the same level of equality as white citizens. But we do not see any further remedial processes in order to remedy past discrimination.
So I want to follow up on something you just said there. So you said that the 14th Amendment was passed and ratified in part to bring African Americans up into equal status with white citizens. If that's the case, then why aren't remedial measures like ensuring that African American students are adequately represented in higher education? Why are those measures unconstitutional in your mind?
In our minds, the affirmative action policy at UT is not narrowly tailored. And because it's not narrowly tailored, it's violating equal protection. We're not saying that all affirmative action policies are unconstitutional, but we are saying that UT has used the policy incorrectly. There are many examples in college education systems where affirmative action has been deemed constitutional, such as Bakke and Grutter, not Bakke, excuse me, but Grutter. And if you use a critical mass, that's one example where affirmative action is permissible and you can use that. But at University of Texas, they are using a quota system which invalidates and makes their admission policy unconstitutional and violates the 14th Amendment.
I want to go back to your point about narrow tailoring, and I just want to make sure that I understand the cases you do. So first, can you tell me what the compelling interest is, since you acknowledge that there's a compelling interest here, right?
We do acknowledge that there's a compelling interest. The University of Texas has a compelling interest for diversity.
Mm-hmm. And tell me why this particular system is not narrowly tailored, and if it's not, do you have a sense of how it might be narrowly tailored?
Yes, it is it's not narrowly tailored because they use a quota system. In their proposal, they said that they define diversity as 2 African American students, 2 Hispanic students, and 2 Asian American students per each classroom. This is a quota system. It's making sure that there's 2 minority students of these minority races in each classroom. That is a quota system, and that violates narrowly tailored, as we saw in Bakke. Furthermore, if the school or any school wanted to have a constitutional affirmative action system, they could look to the precedent of Grutter, of having a critical mass, which is a more of a vague understanding of what constitutes diversity in a student population. And critical mass and quotas are completely opposite. In Grutter, you saw critical mass as being as many as minority students as there can be in order for minority students to not feel subject to prejudices or to feel singled out in their community. But as a quota system, if they're setting this 2 minority student limit, they're being singled out. If there's only going to be 2 of them, if there's only going to be 3 of them, then they're singled out, and they know that they're being singled out for their race.
And how do you respond to the University of Texas's assertion that they don't have a quota system?
Well, I would just look to their proposal. In their proposal to consider race and ethnicity in admissions, they added race as one of the factors to determine admission to their personal assessment of students.
So, Counselor, the university says that if they did not use this affirmative action policy, they would not be able to make their classrooms diverse. That is, they would not be able to have a sufficient range of people of different ethnicities in their class. And the schools argue that this would make education harder. That would make it harder to teach students without this backgrounds. How would you suggest the university could go about implementing some sort of policy that could make their classroom look more like the composition of the state of Texas, where the school resides?
I think that there are many other ways that the university can go about this. They already have the 10% rule, which does let in the minority students who deserve to be there and who have the academics to prove themselves at the university. But if they want to represent Texas, the Texas population at in a just way, then they do need to find out a different system of doing this, because the affirmative action system right now actually is misrepresenting the Texas population. According to the Texas Department of State Health Services, and an approximate ratio, they should have for every 113 white students, 28 black students, and then 91 Hispanic students admitted. But at their ratio right now, they have approximately 102 students who are white, 9 black students, and 33 Hispanic students who were admitted in 2008 for first-time undergraduate speaking degrees. Their ratio, they are grossly misrepresenting the Texas population. The 10% rule is a sufficient way for the moment, but you do have to get the extra undergraduates in there. So I think that, so no college has actually tried to do an income-based affirmative action system, but it actually would work, because the president of Adrian de Pena said that race is not a sufficient condition for the assumption of disadvantage and the subsequent award of favored treatment. But income could be a sufficient condition. Plus, they're, according to a Pew Center research study, African Americans, on average, whites are make 13 times more income than blacks, and 10 times more than Hispanic. So we see that there is disproportionate income and race are related. So it would be a more just way of an affirmative action system. But no college has tried it yet, and I would understand that colleges would be wary of the system, because a college is a business.
So, Counselor, if I may ask a question, one of the other rationales for affirmative action that's been discussed is it's viewed as a way of remedying past discrimination, the idea that certain groups have been oppressed for so long that they're not starting at the same point as other races. And that this policy, even if it's perhaps unfair, and even if indeed perhaps there's a quota, helps groups that have been historically oppressed move ahead to the starting line, perhaps even give them a head start. Do you find that argument compelling?
I do not find the argument compelling. After the slaves were freed, there were measures put in place. There was the Freedmen's Bureau, which helped slaves with very basic education. It was a very basic institution, which brought slaves up to the same education level. It tried to help them breach the gap between whites and slaves. But at this point in our history, African Americans are contributing members of society, and it would be grossly negligent of the law to give them favorable treatment above the law.
So you mentioned the Freedmen's Bureau Act, and then one of the arguments, which I'm sure the other side will discuss, is that the Freedmen's Bureau Act is indeed evidence that the framers of the 14th Amendment in that generation were comfortable using race-conscious measures. In terms of her history and originalism, how do we interpret the Freedmen's Bureau Act in terms of the 14th Amendment? What impact does that have on your argument?
There's actually a lot of different opinions around the Freedmen's Bureau and the acts that extended it, such as the March 3rd Act and July 16th Act, which extended the prevalence of the Freedmen's Bureau. But I think that we think that if you look at the Freedmen's Bureau and then you look towards the 14th Amendment, I think that the Freedmen's Bureau was, it was just a function of the time. It was not meant to be extended through the 20th century, even to the 21st century, although there was such education that extended such as Howard University, which is a great opportunity for African American students to be with people who they believe can share the same interests and be united as one.
So, Counselor, are you proposing that if there's a separate school established specifically for African American students, that's adequate? Not that they be fully and healthily represented on college campuses nationwide?
No, she was just saying that at the time, Howard University was a good step. Yeah, no longer should we look towards a segregated community in education. Howard University was a good step in the 1860s and 70s to get there. But today, even if you look at the university as the California State University, they're colorblind. Why should we not go to a colorblind system where people are not based on the color of their skin, but of their achievements and their intelligence?
Okay. Counselors, you have about a minute left, so if you want to close up this portion of your argument, go right ahead.
The University of Texas at Austin system of affirmative action is an holistic admissions policy that lacks individual consideration for admission, and which results in admission being granted or denied solely on the basis of race, and further violates the Equal Protection Clause, and is not narrowly tailored to the university's utilization of a quota system. We would just like to reiterate the fact that the University of Texas at Austin does not have a narrowly tailored system. Their use of a quota violates already the ruling stated in Bakke, and they do not consider admissions as a holistic program, which is not the efficient way to pass strict scrutiny. Furthermore, we would like to draw the connection between the 14th Amendment and this topic, because in Adder and Britannia, the underlying principle, the court explained, is that the 5th and 14th Amendments protect persons, individual persons, not groups of people.
Thank you, Counselor. Your time is up.
Thank you.
Thank you.
And respondents, you now have 15 minutes. Let us know when you're ready to begin.
May it please the court. We are here to prove that race-conscious affirmative action is consistent with the Equal Protection Clause of the 14th Amendment of the United States Constitution, which states, "No state shall deny to any person or any jurisdiction equal protection of the law." Miss Abigail Fisher first applied to UT Austin in the fall of 2008 and was denied admission. Since she was not in the top 10% of her class, and instead she was in the top 12%, she did not qualify for the top 10% rule, which admitted every single student that graduated in the top 10% of their class to the public universities in Texas. Since this rule did not apply to her, she was reviewed through a holistic admissions process that took into account her talents, test scores, race, and much more. Fisher achieved a grade point average of 3.59 on a 4-point scale and 1180 for her SAT score. Ms. Fisher is arguing that she is denied admission solely based on her race, as she claims she met UT Austin standards for test scores and GPA. She is arguing that she was racially discriminated against during the application process, and we are here to show you that this is simply not true. First off, diversity is a compelling state interest, and therefore UT Austin's process has a solid purpose. Secondly, affirmative action is necessary, and the 10% rule is simply not enough to solve the issue of diversity on college campuses. Lastly, the process at UT Austin is narrowly tailored, as race is not a deciding factor on an applicant's admission or rejection. Rather, it is one of many factors considered. As race falls under the realm of strict scrutiny, it must have both a compelling government interest and be narrowly tailored. In the 1978 Supreme Court, Regents of the University of California v. Bakke, the court ruled that diversity was a compelling state interest, as it works to provide students of every ethnicity equal opportunities in accordance with the Equal Protection Clause of the 14th Amendment. Secondly, the top 10% rule was instated in certain colleges in order to promote diversity. However, it is simply not enough to solve the issue of diversity altogether. A study conducted by Education Next in 2014 actually showed that 43% of students who graduate in the top 10% of their class are Caucasian, and that of the students in the top 10%, over 59% attend private or out-of-state universities, not public universities like UT Austin. This shows that the top 10% plan, while seemingly effective, actually has very little impact on the minority students in Texas. Also, UT Austin stated the top 10% rule in 1997. However, 5 years later, into this process of attempting to diversify the campus, UT Austin conducted 2 studies which found that minority students were still underrepresented on campus. UT Austin conducted these studies to determine if they need to take further action in the application process to diversify the campus. In the first study, UT Austin examined classes of 5 to 24 students. They found that of these classes, 90% had 1 or 0 African Americans, and 43% of these classes had 1 or 0 Hispanic students. These classes did not represent the diverse population of the state of Texas and the nation as a whole. They demonstrated that the top 10% rule did not have enough of an impact on the diversity of the classroom. In its second study, UT Austin surveyed undergraduates on their impressions of diversity on campus and in the classroom. Minority students reported feeling isolated, and a majority of all students felt there was insufficient minority representation in classrooms for the full benefits of diversity to occur. Both of these studies demonstrate that the top 10% rule, which had been in effect for over 5 years, was not enough to diversify the campus. Race needed to be another factor in the application process. UT Austin's president, Mary Faulkner.
I'm sorry to interrupt. Counselor, if you can tell me what limits exist on how colleges can use race in admission. What are the limits that exist?
Excuse me, can you repeat the question, Harlan?
I'm sorry. Under the current law, what are the limits that exist on how colleges can use race in admission? What are these limits?
Well, as our colleagues said before, race cannot be a quota system. So the colleges cannot assign points to a certain race. They can't give white people 0 points and then a minority student more points simply because of their race, because it undervalues the individual itself and doesn't take into account their talents or their personality or their accomplishments in the school. So the school can't look at race as a sole factor, which UT Austin did. UT Austin looks at race as one of many factors in deciding whether a student should be admitted or denied.
How do you respond to petitioners' claim that you have functionally set up a quota system, that this is really based on numbers and not necessarily on, evaluating applicants on a holistic basis?
Well, I think you can see in what happened in 2008 that it wasn't a quota system, because Miss Fisher, yes, was denied, but she was not the only white person to be denied, and white people were not the only people to be denied. In 2008, 168 Black and Latino people who had grades good or better than Miss Fisher were also rejected. So if we were attempting to have a quota system, we obviously would have let these students in because they had better grades, because they were seemingly better than Miss Fisher. But race was not our only factor. We had to take into account other things, and that's why we don't have a quota system. We didn't.
Tell us a little bit more about these other factors that you take into account in addition to race.
Well, obviously we take into account test scores, so that's why we stated earlier that Ms. Fisher had an 1180 on her SAT, and compared to the average UT Austin acceptance score, that's not very good compared to the other students who were accepted into the school. They also take into account their extracurricular activities. And Ms. Fisher was involved in numerous extracurricular activities outside of school. So we would take that into account, as well as her grade point average, which we already stated was 3.59 on a 4-point scale. We would take into account her leadership abilities, her personality in general, the personal essays that she has to write in order to apply to the college. There are numerous factors that go into whether a student is ready to come into UT Austin and make it the most that they can make it.
So, counsel, let me ask you this question. Should the courts be willing to trust that school administrators are actually faithfully executing these policies, right? How do we know that you're not coming to court here and telling us all these great things about all these other factors, but behind the scenes, under the curtains, right, you're actually just using race straight up as the main factor? How do we know, right, that this is actually being complied with constitutionally?
Well, actually, you can see, as we already stated in these facts, that in 2008, 168 Black and Latino students with grades good or better than Ms. Fisher were denied. You can see that we took into account other factors beyond just their race to whether they should be denied or admitted. Also, when the university offers provisional admission to some students that had lower test scores and grades than Ms. Fisher, But when we look at this, only 5 students who were admitted via the provisional admissions were minorities, and 42 were white. So there's a mix here. You can't see, there's not a clear pattern that all minority students were admitted and all Caucasian students weren't, or all Caucasian students were admitted and minorities were not. There's not a clear pattern, which obviously shows that each individual was examined on an individual basis, showing that our process is in fact narrowly tailored because we looked at each individual and each individual's personality and factors and education in order to determine if they were a good fit for our school.
And so let me ask a follow-up question. In the case of Grutter, the Michigan affirmative action case, Justice O'Connor made a statement that you said, you know, we only need this for another 25 years, right? In 25 years, we won't need affirmative action. And your colleagues on the other side said, you know, maybe this sort of policy was good in the time of the Civil War. Maybe it was good during the Jim Crow era. Maybe it was good during the 1960s. But I mean, we're in the year 2016. I mean, we're in a very different place than we were decades ago. Do you see affirmative action as having a logical stopping point, or when we'll no longer need these sorts of policies? At what point does this end?
Definitely, I agree with Justice O'Connor, who said that in 25 years or around sometime in the future, we might not need affirmative action. It could be a possibility. However, at this moment, we do. And the University of Texas, one of their main goals is to create leaders of Texas. And Texas as a whole has a very diverse population, and the school right now doesn't reflect that. As my colleague said earlier, some of the classes had 1 or fewer Black and Hispanic students in them, and that obviously is not a good representation of the population. And if these students are supposed to be leaders, they need to know how to interact with people of different cultures and different backgrounds. So right now, the school is not acceptable in diversity. It doesn't have the diversity that it needs to educate students on not only classroom skills, but life skills in general. And maybe in the future, once affirmative action has taken place over a couple of years or many years, there will be a time when the campus is diverse and it is a genuine representation of the population.
Question?
No, go ahead, continue.
So if I can ask, if I continue the theme of questions, how will this court know, right? You're asking us at some point, maybe we won't need this. How will this court know if it's okay to pull the plug in affirmative action? How will we know that?
There could be numerous factors. I think, you know, one could just be a couple of, you know, there's no real good solution, but one factor could be one school stops affirmative action and is colorblind, and then they take into account, you know, like what is their diversity after a year of being colorblind? What does their campus look like now? Is it diverse? Does it show the population of the city or the state that they are in? You know, I think there would have to be a certain test necessarily to be done, because you can't just look at a population out of the blue and say, oh, it's diverse, because that would obviously have been affected earlier by affirmative action. So you'd have to kind of have some test campuses, which obviously is not ideal, but there's really no way other than that to see if affirmative action has worked.
And you can't exactly set an exact number of years until like, oh, once we reach like 32% or like we have an even number, because that would then be meeting the quota system. So we can't know for sure until we like take it year by year and see.
So this raises another question, which is a diverse student body. That by definition is sort of a hazy term, right? So do you even know within the University of Texas at Austin when you've reached the mark of having a truly diverse and representative student body?
Well, in the University of Texas, as I stated, we are trying to raise leaders of Texas. And so for us personally, a diverse student body means that our population is very similar to the population of Texas. And the percentages of the different races in Texas are similar to the percentages of the different races on campus. We want to break down stereotypes and promote cross-racial understanding and prepare students for an increasingly diverse workplace and society. And those are a few quotes from our proposal to consider race and ethnicity admissions.
So let me ask you this. So petitioners raise the possibility of doing income-based affirmative action, not race-based affirmative action. What's your response to that?
It is a great idea in thought, but then I think in practicality, if we admit students of lower income, that places a higher burden on the school to provide financial aid. And if we are trying to provide financial aid as well as great education, there will be something will have to decrease. Our education will go downhill, or we won't be able to provide those students who need financial aid. And obviously we want students of all diversity or all ethnicities to come to our campus, but I think our process right now is better than income-based. We obviously look at a student's income, but it's not the one factor, as we stated earlier, as race is not the one factor. We want a balanced student body, so obviously we will take in certain lower income students, but if we take in all lower income students, that's physically impossible for a university to do.
So,
Okay,
Counselor, if I can ask one last question. Justice Thomas has often written that he was admitted to Yale University Law School because of affirmative action. And he's often explained that he feels cheapened by that his degree was cheap. He put a little cigar sticker on his diploma because he didn't care much for it. How would you respond to a student who's admitted probably because of affirmative action and who's doubted that he was smart enough to get on his own merit? How would you counsel such a student?
Well, first, as we've stated many times, race is one factor. So obviously they didn't just get in because they were a minority student. But I think we also have to look at the culture of the school and the student and just society in general. If the justice is feeling that way, then that's probably because other students were treating him as if he was inferior due to his race. And that's obviously a larger issue that we are trying to tackle by having diversity on campus, because if we have diversity, then we are more aware of the students as a whole, and we see past their outside race, and we see who they are, what their talents are, what their accomplishments are. And I think his comment is more saying that our society needs to be fixed, not necessarily the affirmative action process.
Okay, you're a little bit over time, but why don't you go ahead and take 30 seconds to close, and then we'll allow petitioners some rebuttal time.
Okay. So UT Austin considered each applicant's credentials and race on an individual basis, meaning their affirmative action process was, in fact, narrowly tailored. Rather than striving to reach a specific number of minority students, the university strove to create a campus environment that was full of smart, engaged, and diverse students from a range of backgrounds. As stated in UT Austin's 2004 proposal to consider race and ethnicity in admissions, diverse student enrollment breaks down stereotypes, promotes cross-racial understanding, and prepares students for an increasingly diverse workplace and society. Thank you.
Thank you, counselors. Okay, petitioners, you have 5 minutes for rebuttal time.
Your Honors, we would like to just reiterate that, as the respondents have stated, that their campus is an equal and good representation of the Texas population is not true. As we stated before, there is an unrepresentative ratio of students who are admitted of minority status to that of white students to the Texas population. Furthermore, to rebuke the respondents' argument about income-based affirmative action, something that has been brought up in the 2016 presidential election is federally subsidized college. The thing is that attitudes about education start at kindergarten. They don't start at college. So some minority students in lower income households or communities may feel like college is not an option, so their attitude throughout the years towards education diminishes, and then they don't have the test scores or the grades to get into college. So if there was a federally subsidized college, then more students of minority races could feel like they can afford college. And
I'm sorry, counselor, to be tough on you about this, but it really sounds like you're arguing again for segregated schools.
No. At the University of Texas, they could easily put in an income-based admissions process. They just have to get rid of race as a factor in their admissions process, which is violating narrowly tailored, which violates the equal protection clause. By them putting race on their admissions application, they are violating narrowly tailored because they are using a quota system and they're not passing strict scrutiny, which is the basis of our argument. And by implementing an income-based admissions process, they're not asking your race. They're not subjecting you to revealing and putting prejudice into your admissions system. Income-based would allow those students who are not financially able to, possibly pay, or who there is a socioeconomic connection to race, obviously.
Let's assume that your friends are correct that there is no quota, and they argue that there's no quota. Let's just assume for a moment that UT is not using a quota. What if, in fact, they were actually using race as one of many factors? Would you be okay with that?
If they were using race to gain critical mass, as stated in Greater, to attain diversity on their campus, that would be narrowly tailored and that would pass strict scrutiny, but they are not. They are using race as a quota and it violates narrowly tailored. They are violating the Equal Protection Clause of the 14th Amendment.
Okay. And so let me ask you a question here. So say, for example, we rule in your favor and we rule that, Texas can't use affirmative action policy and they're stuck with this 10% thing. And your opposing counsel say that the 10% plan has not been adequate for increasing diversity. Short of doing this income-based admission, is there anything else the university could do to have a more representative class? Is there anything else other than the income-based plan that you proposed?
There are, as we mentioned, free college or even looking towards free community college, which could increase the education of minority students in Texas. That is a possibility. As you see here in Oregon.
So that's not the responsibility of the University of Texas at Austin to establish free colleges. So what is it that the University of Texas at Austin has within its authority to do to ensure that its student body, not the student body writ large of Texas, but its student body is more diverse?
They have a responsibility to make sure that they had the responsibility to make sure that their affirmative action system was narrowly tailored. And they did not do that. They did not follow the precedent in Bakke, and they did not follow the precedent in Grutter. And so it would be challenging for the University of Texas to go further, but that is in ensuring that there's more diversity, but that is because Texas as a whole and the University of Texas has a history of not being diverse in the first place.
There's also the University of Texas can become colorblind, as we see in California today. Their proportion of minority students skyrocketed after they became colorblind. Their Asian American population went up because of those deserving students being able to be admitted into schools. The University of Texas could just as easily do that, and they might see maybe through test trial an increased proportion of minority students who are deserving and able to get accepted into college.
Thank you, counselors. You're out of time.
Thank you.
Thank you.
Thank you, counselors. Respondents, you have 5 minutes, please. Whenever you're ready, please begin.
So our colleagues have stated numerous times that we are not narrowly tailored, and I'm sorry that I'm repeating myself, but the facts simply don't say that. In 2008, 168 Black and Latino students with grades good or better than Ms. Fisher were denied. That's obviously showing that we considered each one on an individual basis and that we didn't simply pick them because of their race. And also with our provisional admissions, people or students with lower test scores and grades were admitted with Ms. Fisher, but only 5 of these students who were admitted were white, or 5 of those students were minority, and 42 were white, also showing that race is not a main factor, it's one of many. And we look at each individual to look at their accomplishments, their talents, what their school report is like. We don't look at them simply because of the race. And so to continue on that, after the 10% rule was instated, the fall 2002 freshman class at the University of Texas included 13.6% Hispanic, 3.4% African American students. In comparison, the statewide demographic figures show Hispanics are 32% of the state's population and African Americans are about 11%. Clearly, the 10% rule was not doing enough to increase the diversity on campus. We need affirmative action. And in smaller classes at the university, this is still like continuing on with before affirmative action was put in place. 90% of classes had one or no African American students. 43% had one or no Hispanic.
Sorry, I don't mean to interrupt, but your time is somewhat short in the rebuttal.
Sorry.
You know, you're doing a lot of counting, right? And I know you're saying you're not doing a quota, but you're counting a lot of You're counting a lot of kids by color of the race. I mean, aren't you really keen on the number of black kids sitting in every classroom? I mean, that's you've been telling these excellent statistics, but you're counting the number of people by their skin color.
Right, but the thing is, we're counting them before we put in place this affirmative action. We were counting to see, do we actually need it? Is our school a representation of our population? And with our facts and with our counting, it's obvious that it wasn't. And
but you're also counting after. You're counting before. You're counting after. You're counting. You're quoting. I mean, you may not be saying explicitly, but how does it suggest to the court where you're so obsessed is the wrong word, but you're so focused on getting your numbers just right, just that right number? Isn't that exactly what Baki told us that we cannot do?
I don't think we've been obsessed with getting the right number. We've simply stated that a number of students who were of minority and who were of Caucasian descent were admitted or denied. We're not saying, you know, like we have exactly 10 students of minority race in each class. That's not exactly what we're saying. We're saying looking at what who we admitted and who we denied, it's obvious that we're not doing a quota system, or that we're not attempting to give each race a number or a value. We are trying to look at students as individuals.
So, Counselor, if I can ask, you say you want a critical mass. In your mind, how would you measure a critical mass? What metric would you use to assess a critical mass?
I think that's what we would look at our population again, and maybe see what.
I mean, I don't interrupt it, but isn't that a quota? If you say, for example, I don't know the number, the Hispanic population of Texas is 25%. Okay, so we want a 25% Hispanic population of our student body. Isn't that a quota?
No, I think it is a quota and it is a number, but it's not what we're going off of. When we apply, or when we are looking at the individual students and we're reviewing their applications, we're not looking and saying, oh, we already have 24% of our Hispanic population filled up. We cannot admit this person, or we have to admit this person so that we reach that 25% mark. We're simply saying if we reach it, like fabulous, and we have looked at our population and we have seen that there's a problem and we have tried to solve the problem.
Very good. Okay, Counsel, you have about 30 seconds left if you want to wrap up.
Okay, so our Dean of Admissions stated that he said, we have used race-neutral policies for 7 years and still do not have a critical mass of African American or Hispanic students in our classrooms. He went on to say that majority students cannot reap the educational benefits of diversity when a high percentage of their classes have no or little minority representation. It is our job as a school to prepare students adequately for a more diverse environment when we're training them to be leaders of society, and just prepare them for that. Thank you.
Thank you.
Thank you. Okay, so I'd like to thank both teams. You all did a wonderful job. I think you're very sophisticated, ambitious arguments, and I'm very proud of you. What happens next is actually immediately after we finish talking with you, we will be judging another 2 teams. And then probably the next day or so, we'll be announcing the winners of who move on to the final round, which, as Julie said, we held at the National Constitution Center in Philadelphia. So there's a good chance that maybe one of you teams will have a trip to Philadelphia coming up in the near future. So thank you very much. We give you a round of applause.
Yeah, and I just want to I just want to reiterate what Josh said. All of you did a really wonderful job responding to some pretty tough questions, and we asked tough questions because we thought that you were prepared to answer them, and so we didn't hold back. And I hope that you see that the toughness of the questions was really based on how well you were doing. So I congratulate you again, and we will be in touch soon with whether or not you will be advancing to the final round. So congratulations again.
Okay, thank you so much. Have a great day, everyone. Bye-bye.